today, so we may be broadcast on YouTube. We're going to go ahead with the first case, but first off, let me introduce my colleagues. To my left and your right is Judge Roger Ganem, and to my right and your left is Judge Joshua Mize. All right, let's move on with the first case. It is 23-4106, Elise Samuel Caballero Quinones versus Kyle T. Wilder et al. Good morning.
My name is Justin Blakely. I represent the appellant. If I could reserve 2 minutes of my time for rebuttal.
2 minutes, okay. Let me adjust that. Okay, and you may begin.
Great. All right, so this was a car crash case, and the facts are a little bit important. So liability was hotly contested. The facts were that the sheriff vehicle, or the defendants in this case, sheriff vehicle was going through an intersection, and as it went through an intersection, it collided with another car, and they spun out and collided with my client's car. Right. So the sheriff's position at the trial was that they weren't at fault for the crash. There was nothing they could do to prevent it. Our position was that they drove negligently, and if there were things they could have done to prevent it, they could have driven more safely through the intersection. So,
Counsel, I know the motion in limine was litigated at length. Is there a transcript of the hearing, the motion in limine hearing that was held before the trial?
No. So the only record of the arguments are the trial transcript records.
Is there an Applegate issue because of that?
That wasn't raised below. I thought that
Applegate issues can't be raised below.
Well, I
It's an
mean,
appellate issue.
right. It's our position that the full arguments on that motion were addressed at the trial again. So that there's no issue of a lack of record before the court.
But there's no way that we know that, right? And the judge's memory didn't seem super clear because I guess it had been a while ago about the reasoning for why the judge ruled the way that the judge did.
In the transcript, he said he found his notes, and that he remembered how he ruled per his notes, and also, motions in limine, of course, can be relitigated in the trial, which is what this one was. And so it's our position that because it was relitigated and because there was a full record down below and now before this court, that the court has a record on which to make a decision.
Do those rulings stand alone, or is it one ruling that happened in multiple places, or is it independent rulings that we would look at each independently in terms of evaluating whether we have a sufficient record to?
One ruling that happened in multiple places. So there was the issue, because we brought up the issue again to the court, as we thought that the evidence in court merited it, the court addressed again all the arguments every time we brought it up in front of the court. So it's just our position that because it's a motion in limine, because those are evidence dependent, because those can be reheard during the trial, that there's a record for this court to make a decision. And
if you're rehearing it, doesn't that imply it's a new determination as opposed to a continuation of the prior ruling? Because if you're still doing the prior ruling, you're not rehearing the prior ruling. If you're saying they're one continuous ruling and that the trial ruling was a rehearing of the prior ruling, those are irreconcilable answers. You can only have a rehearing of something that's been completed and is now being done over independently.
Yes, but in the motion in limine context, the context for the court to evaluate the issues in a motion in limine change as it comes up in the trial. So, again, it's our position. This isn't like where there was an evidentiary hearing and the court doesn't have record of an evidentiary.
No, but so that's a good point. So the context of the trial is different. You now have more information. Doesn't that indicate it's a separate evaluation of the issue, separate from the ruling on the motion in limine?
I mean, separate, but based on the same record, because it was based on the deposition transcript that was entered into evidence and that is part of the record before this court. So, I guess he was making another determination, but the basis for his determination didn't change because It was all based on the deposition transcript, which is the only.
I'm trying to figure out whether we have a complete record for the ruling that you want us to examine.
Yes, it's our,
Right.
yep,
We don't have a complete record of the limine because nobody got a court reporter, right?
right.
The rulings at trial, we do have a complete record. And so what I'm trying to figure out is the ruling that you want us to look at, is there a complete record of it?
Yes, because it was completely made during the trial. And it wasn't based upon anything that wasn't in the trial transcript and is not before the court.
In the trial ruling, did the trial judge indicate he was incorporating a prior ruling in any way? I know the trial judge recalled the prior ruling, but was any of it incorporation by reference or anything to the prior ruling, or did the trial judge make a new ruling?
He made a new ruling. So, yes, he didn't say he was incorporating anything here before. He said that, he heard some arguments and he made a ruling based upon the arguments that happened in front of him in the trial. And those arguments, were that this is an admission, an admission by the defense that this accident was preventable. And because it was an admission that this was preventable, we thought that the jury should be able to consider that when evaluating the defense's new position that it was not preventable.
I'm struggling with relevancy. How does relevancy play into an admission? If there is an admission, does it just automatically come in whether or not it's relevant? Or do you still look at relevancy?
You still have to look at relevancy. And the relevancy in this case was that the issue was fault, and the admission arguably is an admission of fault. And so that's what made it relevant.
Under a completely different standard after the fact, a disciplinary proceeding.
That's how the defense wanted to put that admission in context. But that's a weight issue for the jury, not a relevance issue as to whether their statement that the accident was preventable was relevant.
Whether it's preventable, that wouldn't establish negligence, but it could be a factor in assessing whether there was negligence?
Yes, yeah. And we thought at the trial court level, we thought that the Lee case was especially on point. That's a Florida Supreme Court case. In Lee, there was an investigation after the fact by an investigator into some alleged negligence at a home for the disabled. And the Florida Supreme Court found that after the fact investigation, which found negligence, which found neglect on the part of of the corporation there, was admissible as an admission. So we thought Lee, in its after the fact investigation, was entirely on point with this.
What was that admission deposition testimony in the Lee case? What was the form of the admission?
The investigator testified in the trial. So he testified in the trial as to his conclusions. He prepared a report before trial, but at the trial in Lee, he testified.
I guess, so normally you need an admission against interest as a hearsay exception, right?
Yes.
And if the person is in court testifying, unless they're testifying to someone else's out-of-court statement, that's not hearsay, right? That's just testimony. You don't need an exception to get that in.
Yes.
So how is it, break that down for me in Lee, why you needed an admission against interest? You don't need an admission against interest for somebody to get up on stand and say, I evaluated myself or my team and we determined there was fault. There's no hearsay there that you need to have an exception to.
Well, so the investigator in Lee didn't witness what happened. So he took statements from lots of people, employees of the company. And so his conclusions were based upon what other people said.
Okay.
Just like in this case, the sheriff who made the statements wasn't actually at the scene, and so his conclusions were based upon what other people may have said.
Okay, so because this was deposition testimony of a party,
Yes.
right? That can come in typically without a hearsay exception. Now, obviously, if he's testifying to hearsay, right, just like any other testimony, that would be subject to hearsay. But just his testimony is not hearsay because it was deposition testimony of a party, which you could just use as testimony at trial. So statements that came from someone else of, hey, this officer said this, assuming they're offered for the truth of the matter asserted, that would be hearsay and you need an exception. His conclusion of the sheriff's office made the determination that Deputy Harvey could have avoided this accident, that's not hearsay, is it?
No, it's not hearsay either, as we are, because it's an admission or because it's a statement.
Well, hold on. It's an admission is a hearsay exception,
Yes.
right? And that's what you need to get in hearsay that would otherwise be excluded. If it's not hearsay, you don't need an exception. And it doesn't matter if it's an admission. You can just testify to it because it's not hearsay.
That's true. Then the issue is whether his testimony was relevant, and we thought it was relevant for the reasons sort of I've discussed before because of it.
I guess what I'm saying is there was a lot of talk in the briefs about whether this was an admission against interest, and I get that for specific statements he made of, hey, this officer said this to me, right? That would be hearsay. But everything else in his testimony, just what conclusions did the sheriff's office reach, that is deposition testimony of a party. That comes in, that's not hearsay. Deposition testimony of a party can be used just like live testimony. That's what 1.330 says.
Yep.
So there's no hearsay exception required or relevant to that coming in, right?
Agreed.
So the hearsay would only be limited to specific statements he testified to of other people.
Right.
The Lee court concluded that both the investigator's statements may come in as statements against interest, but also any statements made to that investigator by employees involved in the investigation. And the court used the term may. It didn't say it necessarily would come in, but it said it may come in.
Sure.
So under Lee, would it be your position that both the Lieutenant Allaire's conclusions as the person who investigated this post-accident, that his conclusions could come in, but also anything that Deputy Harvey said to him in the course of that investigation, would that also come in under Lee, under that statement against interest?
Yes, that'd be our position. Yes.
So help us, a lot has been made of the privilege for accident reports and also the exclusion of citations. So this is a different situation where the police is also the employer. And so do those, the privilege for accident reports and the inadmissibility of citations, does that have anything to do with what you're arguing? In other words, can we separate those out and say, yes, the accident report and the citation given, those stand over here as inadmissible, but we're talking about something different, just an employer's investigation. The employer happens to be the police, but it doesn't have anything to do with those other items?
Right, that's correct. So accident report statements are compelled statements made to complete the traffic crash report. There's this, the investigation of Deputy Allaire wasn't compelled statements made to complete a crash report. So the crash report privilege doesn't apply. And also, the Sacred Heart case was relevant, and you brought it up in terms of the citation. There's no evidence, there's no record that the conclusions of Deputy Allaire were based on the statement, but were based on the citation. And also, the jury would have received those statements
Does
without.
it matter whether they were based on the statement? On a citation? I mean, the statute says citations are not admissible. Right? That's what the legislature chose to do. Such citations shall not be admissible evidence in any trial. It doesn't say investigations based on a citation or that led to a citation or that, contain evidence of a citation. It says citations. So the fact that the investigation was based on or involved the citation seems just wholly outside the statute.
I agree it's outside the statute, but the Sacred Heart case did sort of make that reference. And so, the court would have to determine, I guess, if you thought Allaire was statements were based entirely on the citation, you'd have to determine if you agree with the Sacred Heart case, which is another DCA, or not. So but I agree with you. I agree with that statement that because nobody tried to introduce a citation, then it doesn't really matter if it's based on the citation or
And
not.
none of the testimony, was there any of the testimony of Lieutenant Allaire where that was sought to be admitted where he said a citation was entered?
No, sir.
Can you address 403? When I'm reading the transcript, I'm wondering what the trial court, I guess the spirit of the trial court's oral ruling. Was it under a 401 analysis, a 403 analysis? Was the trial judge concerned about confusion of the issues in the standard of proof for the jury?
So the way it seemed to me when I was there and the way that it seems to me from the record is that he thought that it was a subsequent remedial measure. And then he seemed to really focus on that. And then he focused on the accident report privilege. So I don't think he made a 403 analysis. I think he did, he made legal analysis in that he thought it was a remedial measure and he thought it was protected by the accident report privilege.
And did he also find that it lacked relevance?
So I don't think the record says that, and I don't recall that from the record. I specifically, the record says he made these legal conclusions.
One of those legal conclusions relevance?
No, Judge, I don't believe that's in the record.
It was argued, though,
Yes, it was argued by the defense at the trial, yes.
and it could have been argued at the hearing, but we don't know.
There's no record of the hearing, yep, that's true. But there is, to go again to that point, there is a record of the judge's rulings at the trial.
Counsel, this might go to the relevance issue. In looking at the deposition transcript for Lieutenant O'Leary, this is on, I guess it's page 266 of the record, but the question you posed is, okay, and that's because the sheriff's office found that Deputy Harvey failed to act with due care when operating his vehicle during the crash, correct? The witness, right. So is that statement by Lieutenant O'Leary, is that statement that Deputy Harvey failed to use due care, is that equivalent to the legal standard for negligence? In other words, are those the same thing, or is there something else in the sheriff's department's investigation, and when they conclude no due care, as compared to just the legal standard for negligence?
So that's what the defense argued below. They said, the standards are different. Our position is that that's a jury question. The jury can evaluate that statement and say, well, we think the sheriff was admitting fault, or we think they weren't admitting fault based on that statement. The relevance is that a jury could look at that statement and say, well, the sheriff thought this was preventable, and now they're saying their deputy couldn't have done anything, and those are inconsistent positions. And so that's why we thought it was relevant.
How would the sheriff's office have gotten that question before the jury? Would it have been, like, for example, at trial, up to the sheriff's office to put Lieutenant O'Leary on the stand and say, explain what you meant by due care, in that post-accident investigation, and then argue that that was different from the legal standard for negligence? Or is that your burden to show affirmatively that this investigation standard that Lieutenant O'Leary used is the same as the legal standard for negligence, or to point out the differences?
So I think that the explanation of the statement should have been on the sheriff's office, because they were the ones who didn't want the jury to credit that statement. We weren't arguing that there was some legal determination that the jury had to follow. We were arguing that the defendant's statement about fault was relevant for their consideration because they were contesting fault in the trial.
Also, whether someone was at fault or didn't exercise due care is their legal conclusion. Their conclusion that he could have avoided the accident. That is a factual issue that could apply to various legal standards, right?
Yes, absolutely.
How do we write, I have a concern, if we write an opinion in your favor, I think that these subsequent investigations that the sheriff's office is doing is probably a good thing to figure out what's going on, maybe see if the sheriff needs to be disciplined. How do we write an opinion that's going to cover this entire district, be the law of this district, without kind of discouraging those types of investigations and candor that goes into them and all of that, if there's a concern that this is going to be introduced into evidence in every negligence case?
Certainly the two sides of it can be separated. So any punishment, or training that the sheriff's office gives a deputy, that's not admissible, that can be excluded. So the opinion could talk about the two different aspects of it, whereas, factual conclusions or factual statements about what happened are admissible, but training, remedial measures, discipline are not admissible.
Your position is a 403 analysis didn't happen, correct?
Correct.
Okay. So if we were to reverse, saying that the judge was wrong to exclude the evidence, the testimony under subsequent remedial measures, accident crash report, and traffic citation, that would mean when it goes back down, a 403 analysis is still able to be done, correct?
Yes.
Okay.
Yeah.
So you could go down and the judge could still exclude it on 403, and this could still be excluded, correct?
We think that would be an abuse of
You're-
discretion, but yes.
Well, that would depend on what was presented at that trial, right?
Yes.
So there's no way for us to know now whether it'd be an abuse of discretion, or for you to know, right?
Sure.
Because you don't know what trial counsel, if that'll be you or somebody else. But my point is, you're not asking us for a ruling that this comes in.
No.
You're asking us for a ruling that it was excluded improperly on certain grounds, and grounds that not ruled on are fair game at the next trial.
Yes.
Okay, you're into rebuttal time.
Great. Thank you.
May it please the court. Barbara Davis on behalf of the sheriff in his official capacity. I think the last thing you were addressing to me is the core of this case. And unfortunately, I think you may be correct that the record isn't complete on the issue of the 403 analysis. The 403 analysis, although the substantive substantive remedial measures is a key issue, and I believe is in our favor for excluding this evidence. In the end, if you take all of the parts and you do the analysis, it's a bit of a weighing situation where,
It seemed that you asked us in your brief to affirm under Tipsy Coachman based on 403, correct?
I did, yes. I think
So in order
because
for it to be Tipsy Coachman, that means it's something the trial court did not do, correct?
I believe you're correct, yes.
So you've accepted, you've conceded in this action, in this appeal, the trial judge did not rule based on 403 because if he did, Tipsy Coachman wouldn't be the right argument, right?
Well, I've conceded that there isn't evidence of that in the record because the only evidence is that in the motion in limine, that argument was made. And in the memo in opposition to the motion for a new trial, that argument was made. But in both cases, we never had an order on the motion in limine. They weren't able to find it, and there's no record of there's no transcript of the hearing. And then there's, on the order for the new motion for new trial, there was just strictly an order denying it. So we don't know what the basis was for that in that case.
Can you address what your opposing counsel said about the relevance in any of the places the trial judge ruled? At any of the various points and rulings, did he say that this lacks relevance?
I don't know that he put it in those terms. I don't recall that it being in those terms. I mostly recall that he discussed the substantive remedial measures and then also the citation issue. And in my mind, the subsequent remedial issues measures is an issue that the appellant has kind of divided into the why versus the what. Like, why did they take these measures versus what the measures were? And I don't think you can divorce those two issues.
Let me ask you a question about that. Suppose that in this case, the sheriff's office had done a post-accident investigation and concluded that Deputy Harvey did nothing wrong whatsoever, followed the policies, did everything by the book, it's just unavoidable. Would evidence of that investigation be evidence of a subsequent remedial measure? Because to me, a measure is something that's done to address the situation or to fix it or to make it better next time. But simply investigating to ask the question, was something done wrong? How is that a measure under the rule excluding subsequent remedial measures?
I think that, again, I mean, if I were on the other side of that issue, certainly I would say that it still shouldn't come in because in that case, they're looking at their policies and they've found that to be honest, in most cases, their position is if the accident happened, we don't really care how it happened. There's something that needs to be done. We need more training. We need discipline just because it happened, just to try to do everything they can to protect the public interest. And I think particularly when you have a specific action taken, there's always going to be an analysis of why is this necessary? If it isn't broken.
Yeah, but there could be a lot of things. There could be a budget for the subsequent remedial measures. There could be an analysis that leads to it. We're not here deciding like what does it make sense to exclude or what we think is a good policy. There's a statute on this.
Right.
The legislature looks at all the things that go into this, and it said evidence of measures are admissible, right? That's what the statute says. It does not say investigations that led to measures or that were used to determine whether measures were put in place. Where would be the textual basis in the statute for excluding anything other than the actual measures taken?
I think that it is evidence of measures taken. When you have made the analysis that measures are necessary, then that is evidence of the measures
Is
themselves.
anything they tried to put in saying this analysis led to measures? That based on this investigation, we disciplined him?
In the
In the
Dr.
testimony that they wanted to admit?
Lieutenant,
Is any part of the
Allaire's.
testimony they tried to admit include something where Lieutenant Allaire says, based on this investigation, we took measures, including discipline or training?
he does talk about the fact that they did the investigation.
That's not my
He-
question.
Yeah,
Specific question, I want an answer.
okay.
Is any of the testimony they tried to admit included Lieutenant Allaire saying, based on this investigation, we disciplined him or took some other measure?
I don't recall if he said that specifically in his
He didn't.
testimony.
So how can the investigation, without any mention of measures whatsoever to the jury, be evidence of measures? Is the answer that it can't?
I respectfully disagree that I believe that it's all part of the whole process. It's part of the process that you go through in taking any remedial measures, and to allow that to be separated from the measures itself is allowing what you're going to use as an exception for impeachment purposes. And as 11th Circuit has warned, if you allow that to be used, you're gonna
Well, we're not
engulf
on
the whole
exception, right?
rule.
So the exception for impeachment is a way to get in subsequent remedial measures, evidence of measures. If it's not subsequent remedial measures, you don't need to get to an exception because it's not barred in the first place because it's not a subsequent remedial measure. And so what I'm asking you is, how can testimony which in no way mentioned measures of any kind be evidence of subsequent remedial measures?
You may be right about that. I do think, though, that the analysis then moves to where we have a real issue in the lack of the record, is that is something that you would weigh on the side of prejudice versus
Okay,
probative
all right.
value.
So subsequent remedial measures, I'm taking that as a concession. It was not properly excluded into that because you just told me it's not evidence of measures, but you're saying 403.
Yes.
Counsel, I want to ask about the record issue, because when I look at the parts of the transcript where the issue was raised, again, it was raised several times, and the first time, and this is on page 910 of the record, trial counsel says, Judge, 3 reasons why you granted our motion in limine to preclude this very thing. 1, everything they want to put in is hearsay after the fact. 2, it was a review process for training. It has substantive remedial action, which we all know how that works. And 3, the relevance. Given that we don't have a transcript from the first motion in limine hearing, why can't we rely on trial counsel's statements to the judge? These are the 3 bases you made your ruling on, and those 3 bases don't include 403. And we add to that as sort of as a bookend your statement in the brief that the trial court did not specifically rule on the basis of 403. Can't we rely on those things and be confident that 403 was not part of the trial court's original ruling?
I don't think you can rely on that. I mean, I think you can rule on that basis if you're willing to say, just strictly on what the record is, and we don't know what happened with the 403 analysis.
Well, hold on. His question is, can't we say we do know because you've made a concession? If you say in your brief this didn't happen, we're entitled to rely on statements in your brief, correct?
Yes, yes.
Okay. And you say in your brief the trial judge did not make a 403, did not rule based on 403, correct?
I guess maybe I misstated. I think what I meant was that in the record, there's no statement of what his position was on 403.
But isn't trial counsel for the sheriff stating affirmatively to the court, these are the 3 bases for your ruling, Can't we rely on that also as a concession? I mean, do we need to look past that?
No, I think you can rely on that. I think then we're just going to get to the issue that you brought up earlier, that this will probably end up back here once it goes back down and we fully, develop the record on the issue of the 403 analysis, and then it will come back here on that issue. So, I mean, under the 403 analysis, I think it is weighed so heavily, I believe, for all of the reasons of the subsequent remedial measures, even if it doesn't fit technically into that rule, and also on the citation, the kind of the end around of getting the evidence of the citation, because although he didn't mention citation, he several times testified that there was a failure to yield the right-of-way, which was what the citation was.
Counsel, two things. Number one, in your brief, what you said is, you clearly made the concession. You say the trial court did not specifically base its decision on the Rule 303, on the Rule 403 standard. Appellee is not suggesting that the trial court reached the right result for the wrong reason, but implying that, 403 was not the basis. So it doesn't seem like you were saying in your brief that it's not specifically in the record where he made a ruling based on 403. You seem to clearly say in your brief he did not base his ruling on 403.
Right, as far as the record, we have no evidence that he did. There's no evidence of that.
So to clarify, you were talking about going back down to the trial court for a 403 analysis. Can we not tipsy coachman this and affirm it on 403, given what we have?
I believe that you can, because I believe that the record was developed sufficiently to be able to do that. Both taking all of the analysis on the subsequent remedial measures, the analysis on the use of the evidence of a citation, although that word wasn't used, even though it may not technically fit into that statute.
Counsel, doesn't that presuppose that talking about an analogy to subsequent remedial measures, that we can just assume that that's an analysis of prejudice? So it's not like the legislature said in the statute, subsequent remedial measures or citations are inadmissible because they're prejudicial. That's just an assumption that they relate to prejudice. There could be other policy reasons the legislature did that, such as encouraging people to take subsequent remedial measures.
Absolutely.
Right? It's not that they're prejudicial. We just don't want people to have fear, right? Talk about the accident report. That could be to encourage candor in accident reports. So to say, well, he analogized this evidence, even though it didn't fit within the statute, he analogized it to the statute. We should find that's a prejudice finding, even though he didn't say it, just assumes that analogizing something, that those statutes are based on prejudice, and that we can kind of extrapolate that as a prejudice finding. When the statutes don't mention prejudice, we have no idea why the legislature did it. And the trial judge didn't say, I find they're prejudicial in the same way as those things. So I found they're like those things, but what's the leap there that gets you to that's a prejudice finding?
I think if you are using the tipsy coachman doctrine to make that analysis, I think the prejudice is that you are prejudicing the litigant for taking these measures, and by subjecting the
403 analysis is not prejudicing a litigant and whether they want to take the measures. I mean, that's very far off from what 403 is. 403 is prejudice in the litigation, like trial prejudice, right? 403 doesn't consider out-of-court prejudice of this hurts them outside the litigation, does it?
I'm not sure that the case law is definitive on what all the prejudice entails.
Do you think the case law is open as to whether prejudice for 403 purposes considers prejudice completely outside and unrelated to the trial and the litigation?
I'm quite frankly not sure how far it extends, but I do think even in the litigation there was prejudice because of and again, the record is probably not completely developed on this issue because at the motion in limine, it was ruled inadmissible. And so there was never the live testimony of the lieutenant, but there's prejudice in that, in the deposition transcript even, he indicated that the standard is preventable and that that standard is a different standard than what the,
That's certainly an argument on 403, and I get it. The trial court didn't make that 403, you've conceded, and you're saying we should. When a trial judge makes a 403 determination, so say like just trial judge, I'm excluding this under 403, right? I find the prejudice outweighs the probative value. We review that for abuse of discretion, correct?
yes,
So that means the trial judge exercises his discretion based on things in the trial that we don't see. And it could be the case that the trial judge could have gone either way, and that either way would have not been an abuse of discretion, correct?
I wouldn't agree with that. I would say that,
You think abuse of discretion always means there's only one right result?
no.
Yeah, I'm saying in a
In this
hypothetical case, not this
oh,
case.
Okay,
In a hypothetical case,
yes,
there
yes.
could be instances in which it was close enough that a trial judge wouldn't have abused his discretion either way he went.
Yes,
right?
yes.
And that's why we review it for abuse of discretion is because there's some discretion involved, right?
Mhm.
Okay. Do you know of any other, how can we, assuming it's discretionary, now I know you're saying that the evidence is, all points one way in this case, right? For a discretionary decision, the tipsy coach minute, we can certainly think, would there have been sufficient evidence or sufficient circumstances for the trial court to, for one result or the other to be within the trial court's discretion? I grant you that. How can we know whether the trial judge, as a general rule, not just specific to this case, actually would have exercised his discretion that way?
Based on this record, we don't know, and we certainly cannot, surmise. I mean, I think, I think based on his rulings, on his ruling, you can assume that he might go that way.
We can guess.
But you would be making an assumption, yes.
We would be assuming he would have exercised his discretion one way or the other.
Right,
There's no way we can know whether he actually would have done that, correct?
that's correct,
And normally in 403, trial judges exercise the discretion and then we review it, correct?
yes.
What would have to be developed back in the trial court in order to make a 403 determination that we couldn't make now?
I think particularly it would have to be developed about how these review boards operate, what evidence they're looking at, what their standard is. I mean, there
So are you
are,
conceding that we can't use tipsy coachman on 403?
no. I mean, I was thinking more in terms of just developing the record for the purpose of like the citation issue. And I wasn't thinking so much on the development of the, but, I'm sorry.
Is there any other instance where appellate courts exercise direct discretion over evidence, over admission of evidence, as opposed to reviewing discretion? Is that a thing
I'm not
appellate
aware
courts
of.
ever do ever?
Yeah, I'm not aware of that.
That's something as far as you know, appellate courts
I
don't
mean,
do?
I believe that they use the tipsy coachman as long as the facts have been developed.
I think that was my question.
Okay.
What facts still need to be developed for the trial court to make that determination that we could not make at this point based on the facts that we have before us?
Well, I mean, I believe that the trial court could have made the determination based on the record that was there. But I think that, in hindsight, we would do things would be done differently. And especially if we were concerned about, ending up in this same situation. Obviously, knowing what we know now, we would change that. But even on the record as it was, I think there was enough in the deposition transcript to show that this was a different standard, and that they were relying on the statement of the deputy in this case, the accident, They were relying on the report of the investigating officer. I think that's indicated in the transcript. And those are things, that information normally would not, I mean, this is such a unique situation since they employ the deputy, and also because of the fact that you have the same people who are deciding the discipline and the additional training and that sort of thing. Those same people are the people who investigate accidents, and they're the ones who, their decision about who to ticket, who's at fault, in their opinion, would normally never come into a trial. Yet, because of this review board and because of their efforts to improve upon their training and their policies and using punishment as a deterrent, because of all those that affect the broader public interest, they, there's, the argument is that those should come in. And really,
Isn't it also just because they're a party? Like when some third party says, I think somebody did something wrong, assuming they're not an expert, that doesn't come in. When a party says, I screwed up, that always comes in every case, always, right?
not in every case.
Well,
And in-
unless there's some exception, right, unless there's some reason not to, but
Yes.
generally, when a party testifies in a deposition or at trial, because this was a party's deposition, I screwed up. Isn't that generally admissible?
I think generally, but again, in this case, it shouldn't because of the detriment that you would do to these review boards all over the state and the chilling effect that you would have on what is a great public, what's a public policy of, safety. And I think that gets again into the weighing perhaps of the 403 analysis. But
The legislature has given us several statutes where they say, we don't want this coming in, right? Accident crash reports, subsequent remedial measures. Is there any statute where the legislature said, hey, if a sheriff's office investigates one of its crashes, nothing about that investigation comes in? Is that one of the things the legislature has chose to exclude by statute?
not that I'm aware of, no statute on that.
Okay, your time is up. Thank you.
Thank you.
Okay, can I ask my question that I asked your opposing counsel about what factually still needs to be developed in the trial court to make a 403 analysis?
I don't think there is anything that needs to be developed. The trial court didn't conduct one, but in terms of the record, the trial court could have chosen to conduct one and did.
So you would, if you went back down, you would just be re-arguing the same facts that are already in the record?
Yes.
Okay.
And then just in rebuttal, I think they've conceded on appeal that the record was developed sufficiently. So I think based on arguments of counsel and the lack of argument in their brief that the record wasn't developed sufficiently, that issue arguably is taken care of. And then finally, they argued a lot of policy arguments. It's our position that the court should look first to the law, and then policy should be a lesser argument. But in terms of what the sheriff's offices could do if they wanted to have every deputy who ever got in an accident get training, they could, and that wouldn't be admissible. So it wouldn't affect training.
Counsel, if I could, if you do go back down below and have a 403 hearing, and the sheriff's office puts on more evidence about their process and things like that, do I take your answer to be you still wouldn't put on any more evidence, or would you respond to whatever they put on?
It would depend what they put on, but we thought our position was the discrete statements we wanted to be in, that with those discrete statements, the record was developed enough because it was inconsistent with their position at trial.
Okay.
Thank you, counsel.